Hi, welcome to Albertson and Davidson. We need to discuss something very important, Stewart, and that is the fees that you have to pay an attorney for litigation in trust matters. And so when a trust is contested or there's something to do with a trust litigation, obviously you need to hire an attorney and pay them fees. How much does an attorney charge in a trust litigation matter?
Well, it depends on how complex the trust litigation matter is. If it's hotly contested for several years, those fees can go quite high on both sides. If it's a simple petition that needs to be filed to clear up a title issue, like a Hegstead petition or something like that, well, you're talking less than $10,000. But most cases that go to litigation regarding trust litigation in California, it's going to be expensive one way or the other.
And most of the time, an attorney who's representing a client in a trust litigated matter, they're either going to be charging hourly or contingency. And maybe you can walk us through the difference of what is an hourly fee versus what is a contingency fee.
So the hourly fee is just what it sounds like. Most lawyers that do trust and estate litigation in California charge anywhere between $500 and $1,000 an hour. So if you sign up, they generally require some type of retainer right up front, a $15,000 retainer, $25,000 retainer. They bill against that retainer with their hourly rate. And when they get close to zero or close to 5,000 or some number, they'll ask you for more retainer and you'll replenish their retainer. And that's how the case will go forward. Keep in mind that, if you're in a hotly contested matter, that easily could be several hundred thousands of dollars. And so you need to make sure that you have a budget to pay for those hourly fees going forward. If you only have $10,000 and you can only hire the lawyer one time for $10,000, well, now you might need to think about a contingency fee. And a contingency fee is just simply you're paying the lawyer if they're successful in your case at recovering something for you that you think you're owed. So let's say that you're a trust beneficiary and you've been completely kicked out of a trust that has $1.5 million in it. And there were 3 beneficiaries. You got kicked out a day before your parents passed away. They changed their trust and amended it, kicked you out. Now your brother and sister are sharing that $1.5 million. If you litigate that case and are successful, then you would go to the previous document. And let's say the previous document said $500,000 each, or 1/3 each, essentially. So then your lawyer would recover $500,000 for you of that $1.5 million. And there would be a percentage that would be applied against that recovery. Generally, it's 1/3 to 40%. And that would go to your lawyer for all of their efforts. And then you would get the balance of that money.
So on a contingency fee basis, then you only pay the attorney if the attorney is successful.
Correct.
And what about costs? Because litigations have a lot of costs. You have to pay for deposition fees and subpoena fees and mediator fees. I mean, there can be tens of thousands of dollars of costs. How does that vary in a contingency fee arrangement?
So in most contingency fees, the lawyer, the law firm, will pick up all of those costs. Now, that's not always true. Sometimes there's a really speculative case and there's some fee amount that the lawyer's going to require for them to move forward, plus the percentage, the contingency fee. But in most cases, the lawyer looks at the case and goes, yeah, I think I'll be successful in getting some of this money for you and get a resolution for you. It may be a year from now, it may be 5 years from now. But in the meantime, the lawyer will cover all of the costs going forward. Depositions, filing fees, subpoena fees, experts, you name it, they cover it all. Now, keep in mind, there's no free lunches. If there is a successful resolution, and let's say you do get that $500,000, and there was $30,000 that your lawyer spent on the life of the case, those will have to come back to the lawyer for the expenses that they put out forward, and then they're still going to get their contingency fee on top of that. So keep in mind, it's not just the contingency fee, but they would get their costs back as well.
And then if the lawyer's not successful and recovers zero, what happens with those costs?
In most cases, the lawyer has to eat those costs, and you don't have to pay those to the lawyer. Be careful. I have seen some engagement agreements that say even if the lawyer loses or leaves the case somehow, that the client agrees to pay for all the costs to date. I think that's probably enforceable. We don't do that in our engagement letters, but just take a close look at that before you sign the contingency fee.
So one last question. On our cases where we're doing trust contest cases, those are some of the hardest cases we have to do because you have to try and overturn a trust or a trust amendment, which is very difficult to do. On average, do you think it's better for a client to hire us on an hourly basis or a contingency basis, and why?
So first of all, I don't care how clients hire us. You're our business guy. You're our managing partner, so you deal with more of that. I don't think you care how they hire us. You just want to make sure they're aware of what they're going to be doing under whatever business arrangement they make with us. So again, if you're going to hire us hourly, make sure you have the money to go the distance. And you can ask the lawyers, how much do you think this is going to cost? And they'll do their best to explain, well, generally in these cases, you can expect, this amount of money, but it could be more. So keep that in mind. So if you don't have the wherewithal, if you don't have the ability to withstand the hourly fees and the additional retainers just about every single month you're going to get from your lawyer, then you're going to want to consider the contingency fee. If you consider the contingency fee and do it, fantastic. Me personally, Keith, once you bring a client into the firm, I don't want to know. I really don't care if they're paying us hourly or contingency. I just want to get started on the case and I want to get moving forward. And if there are any financial issues, I always turn those back to you because I don't want to have an adversarial relationship with our clients. I want the clients to talk to you about fee issues that come up, which you are always happy to talk to them about. I want them to look at me as the litigating lawyer going after somebody. I'll say one other thing. Lawyers have a bad reputation and it's probably deserved for many reasons. But when you're going to go pick a lawyer and you're talking about whether you're going to pay them on an hourly rate or you're going to pay them contingency fee, sit down and talk with them. Have a comfort level with them. If you don't feel good about this person, they're probably not the right lawyer for you. If they're a little, you feel that maybe there's a little bit of used car salesman coming out, go on. There's plenty of lawyers that do this. Just go to Google or go to your ChatGPT or whatever it is you're going to search for lawyers and look for trust and estate litigation lawyers in California. There's probably 20 firms in California that really know what they're doing in this area. There's some small mom and pop shops that know what they're doing as well, but there's 20 firms that really understand this. And go interview with those 20 firms if you have the time, at least 3 or 4 of them, and you'll find somebody you feel comfortable with. They'll be able to explain to you the business arrangement, and it's something that you can live with. And then hopefully you've picked the right firm and they can go and be successful for you.
Yeah, and that's an excellent point. And I think what really matters for the client in terms of trying to decide to hire a client on hourly or contingency is set yourself up for success. So if you want to go the hourly route, that's fine. Just understand what you have to have ready to invest in that case. And if that's not what you want to do or you don't have the means to do it, then set yourself up for success on a really good contingency arrangement and make sure that that contingency meets your expectations as to what is going to happen over the life of the case.